Welcome everyone to this talk, which is a refresher on solicitors' duties and obligations under the Legal Profession Uniform Law and Australian Solicitors' Conduct Rules, and some practical tips and strategies for preparing evidence and pleadings. First of all, I'll introduce myself. My name's Shana Clement. I've been a member on Greenway since the floor started in 2016. I came to the bar in 2012 and started my time at the bar on 7 Wentworth. Before I came to the bar, I was a solicitor at Spark Helmore Lawyers, and before that I worked for Justice Richard White as his tip staff in the Supreme Court before His Honour was elevated to the Court of Appeal. My co-presenter, Holly Lamb, has more than a decade of experience as a litigator. Holly was the president of New South Wales Women Lawyers Association from 2017 to 2018. She was with the Australian Women Lawyers from 2019 to 2020, then became vice president of that organisation in 2021 through to 2022. Holly was a senior associate at HWL Ebsworth, and she was working in commercial litigation and insolvency. She was then senior legal counsel at what was then AMP Capital, now Dexus. She has an ARETA Advanced Certificate in Insolvency, and her practice areas are quite broad. Commercial litigation, she works in general commercial, insolvency, she does a bit of building and construction and consumer claims, all kinds of things. And Holly was called to the bar in 2023. So I'll hand over to Holly first of all to do the first part of our talk. I haven't actually got I can actually use the controls. So these are the topics we'll be covering. Holly's going to address the first two, which are big topics for discussion, and I'll take over from the proof before pleadings topic.
Thanks, Shanna. Okay, so we'll start with what we all want to hear about, which is unsatisfactory professional conduct versus professional misconduct. We will then go into fundamental duties, so the things which you should never forget as a barrister or as a solicitor. And then we'll go into proof before pleadings, proof, controlling the evidence, integrity of evidence, conversations, responsible use of court processes, and then pleading and proving fraud. Rule number 1, it is a very small profession. So if nothing else, let's remember to be courteous to each other, bearing in mind that it's not just a nice thing to have, it is actually a part of our ethical obligations. In the case of Griffin and the Council of the Law Society of New South Wales, the Federal Court of Australia dismissed an application for an extension of time in which to file proceedings. The very next day, the court received quite an extraordinary letter. As a result of this letter, professional proceedings were commenced for professional misconduct. At the conclusion of those proceedings, professional misconduct was found, and that finding was upheld on appeal. So what did this letter actually say? Let me read you some of the highlights. As solicitor for the applicant in this matter, I have serious concerns about your conduct and decision in this matter. This is the solicitor speaking to the judge. These are the somewhat immature and inappropriate comments you made to me at the first directions hearing when you responded to an innocent reference to yourself by me as registrar. Suggest that your displeasure in being referred to in that way may have impacted upon your ability to exercise the degree of objectivity required of an officer in your position in determining this matter. 2. The interest in identifying me as solicitor for the applicant on the judgment, contrary to usual convention, indicates you may have acted with some vindictiveness in regard to my client and myself in response to my innocent reference to you as registrar at the first directions hearing. 3. Your own and your associates' obvious familiarity with counsel for the respondent at the hearing. The letter continues on. By the time we get to point 9, it says, Your failure to sign the reasons indicating that the judgment may have been made by your associate and not you at all. Some people really don't know when to quit. It then gets worse and continues on for about another page before we get to, notwithstanding that I consider that our client has grounds to appeal your decision, and that I consider that your conduct in this matter is questionable, and further, that the Australian public and democratic values require and deserve a higher standard of decision-making in regard to reviewing decisions of political officers and their agents than that evinced by your reasons, I consider that many of the points raised above indicate that your decision was likely made without good faith and with bias. On that basis, in reliance upon Rule 39.04, I consider that I should extend to you the courtesy of varying your judgment before it is entered and before I submit it to appeal. He requested various variations of the order and concluded with a request to remove the words from the judgment and other errors of expression at paragraph 21, as no such thing exists, given that whether something is an error of expression is a subjective opinion, and given that you are not an expert in the English language and not qualified to make such a comment or give such an opinion, while I have an honours degree with distinction, including honours in English. Neither you nor your associate are qualified to make this comment, and it displays infant school and pedantic understanding of what language actually is. It should be obvious to all that that is not how you should address a judicial officer. Click. Thank you. Sorry, I forgot about that. So what is unsatisfactory professional conduct? This is set out in section 296 of the Legal Profession Uniform Law for New South Wales. Applies to everyone. Unsatisfactory professional conduct includes conduct of a lawyer occurring in connection with the practice of law that falls short of the standard of competence and diligence that a member of the public is entitled to expect of a reasonably competent lawyer. Some examples of UPC include things like turning up to court drunk. That should go without saying. Double booking court appearances and not giving sufficient notice, and then lying about having obtained consent to appear in two different matters or to abandon one to appear in the other. And also depriving a client of the right to make a free choice. In that case, it was basically the solicitor had formed an opinion of his client and then insisted that he should take a settlement offer that the client did not wish to take. Contrast that to professional misconduct, which is set out in section 297 of the Legal Profession Uniform Law. Professional misconduct constitutes UPC where the conduct involves a substantial or consistent failure to reach or maintain a reasonable standard of competence and diligence, and conduct of a lawyer, whether occurring in connection with the practice of law or occurring otherwise, that in connection with the practice of law that would, if established, justify a finding that the lawyer is not a fit and proper person to engage in legal practice. As you can tell, professional misconduct is a bit more serious than UPC, and it's concerned with improper or incompetent behaviour by a legal practitioner which casts doubt on the practitioner's fitness to engage in legal practice. It's something more than just a one-off generally. It's important because a relationship of trust and confidence between the profession and the court is essential to the proper administration of justice. It should go without saying that if you are appearing in court and all around you are dodgy crooks lying through their teeth and getting what they want, the public's confidence in the justice system is going to be a little bit undermined. In Kennedy and Counsel of the Incorporated Law Institute of New South Wales, back in 1939, Justice Rich said in that case that a charge of misconduct as relating to a solicitor need not fall within any legal definition of wrongdoing. It need not amount to an offence under the law. It was enough that it amounted to grave impropriety affecting his professional character and was indicative of a failure either to understand or to practice the precepts of honesty or fair dealing in relation to the courts, his clients, or the public. The particular transaction, the subject of the charge, must be judged as a whole, and the conclusion whether it betokened unfitness to be held out by the court as a member of a profession in whom confidence could be placed. In 2010, Chief Justice McClelland, in Bashara and Legal Services Commissioner, stated that there are no fixed categories of professional misconduct. Much depends on whether the conduct falls outside generally accepted standards of common decency and common fairness. So some examples of professional misconduct include vigilante behaviour, showing disregard for the law. The lawyer was a bit worried about his own safety and walked around carrying guns. Not a great idea. Preferring your own interests to the client's interests by saying that it's the client's fault when it was the solicitor who missed a limitation period deadline. Abusing court and opposing counsel, including making criminal complaints against opposing counsel with the object of intimidating them to cease representing the client's ex-wife. Willfully misleading the court. Removing documents in contravention of a court order. Permitting conflicts of interest to arise. Failing to account for money received, misleading a client, gross neglect and delay, failing to adequately supervise an unqualified clerk. On that note, solicitors should be aware that if you are going to be supervising juniors, you need to have an unrestricted practicing certificate. So after your 2 years of practice, you need to get that condition taken off your license. Otherwise, technically, you should not actually be supervising any solicitors, associates, paralegals, clerks. Breaching an undertaking given to another lawyer, and in certain situations, criminal and or personal misconduct. Barristers adhere to the Legal Profession Uniform Conduct Barristers rules. Just going to talk about 3 concepts in particular, which are, well, actually, before I get to that, let's talk about the principles that underpin these rules. Barristers owe their paramount duty to the administration of justice. We must maintain high standards of professional conduct, and as specialist advocates in the administration of justice, we must act honestly, fairly, skillfully, bravely, and with competence and diligence. We owe duties to the courts, to our clients, and to our barrister and solicitor colleagues. We should exercise our own forensic judgment and give advice independently, and we must accept briefs to appear regardless of our personal beliefs, and must not refuse briefs except on proper professional grounds. The reasons for all of these, or for these principles, and why they're so important to a barrister, was outlined by Chief Justice Spiegelman in New South Wales Bar Association and Cummins in 2001, where he identified 4 interrelated interests involved in the regulation of the conduct of legal practitioners. First, clients must feel secure in confiding their secrets and entrusting their most personal affairs to lawyers. Second, fellow practitioners must be able to depend implicitly on the word and the behaviour of their colleagues. Third, the judiciary must have confidence in those who appear before the courts. And lastly, the public must have confidence in the legal profession by reason of the central role the profession plays in the administration of justice. In essence, many aspects of the administration of justice depend on the trust by the judiciary and or the public in the performance of professional obligations by professional people. We'll now turn to the 3 key concepts that cannot be forgotten and are probably my favourite as well. If you don't remember anything else, these are kind of the 3 concepts that you really should remember. The first is encapsulated in Rule 23, which is the duty to the court, and that is that a barrister has an overriding duty to the court to act with independence in the interest of the administration of justice. The second big thing for us is Rule 42, which is independence. A barrister must not act as the mere mouthpiece of the client or of the instructing solicitor, and must exercise the forensic judgments called for during the case independently, after the appropriate consideration of the client's and the instructing solicitor's wishes where practicable. The third big concept is in Rules 43 and 58. The highlight essentially is don't waste the court's time. A barrister must confine any hearing to those issues which the barrister believes to be the real issues. We have to have the case ready to be heard as soon as practicable. We must present the client's case as quickly and simply as may be consistent with its robust advancement. We must inform the court of any persuasive authority against the client's case, and we also have to limit evidence to what is reasonably necessary to advance and protect the client's interest. In Janarelli and Wraith, it was stated that a barrister's duty to the court epitomizes the fact that the course of a litigation depends on the exercise of counsel of an independent discretion or judgment in the conduct and management of a case, in which he has an eye not only to his client's success, but also to the speedy and efficient administration of justice. In selecting and limiting the number of witnesses to be called, in deciding what questions will be asked in cross-examination, what topics will be covered in address, and what points of law will be raised, counsel exercises an independent judgment so that the time of the court is not taken up unnecessarily, notwithstanding that the client may wish to chase every rabbit down its burrow. The administration of justice in our adversarial system depends in very large measure on the faithful exercise by barristers of this independent judgment in the conduct and management of the case. The duty not to misuse court time is inherent in the duty to exercise independent professional judgment. That is, don't waste time advancing arguments that are not reasonably open. That the client presses the lawyer to make every point conceivable and inconceivable without judgment or discrimination gives no justification for using the court's processes to pursue a hopeless case. Lawyers may accordingly be expected to exert a moderating influence on their clients and not to allow their clients to control them. From a practical standpoint, there's also the reality of litigation being quite expensive, and no client is going to want to waste money on a hopeless case. So, there are those that come to you that will be like, well, I want to fight on the principle. And those ones I would be very cautious of, because at the end of the day, look, if you've won, even when you've won, clients are frequently unhappy with the amount of legal costs that have been racked up. And if you lose and then you still have those costs, you've got one very unhappy client at the end of the day and wasted the court's time. So turning now to the Solicitors' conduct rules, which have quite a bit of overlap with the Barristers' rules. Again, Rule 3, Solicitors' paramount duty is to the court and the administration of justice, and that overrides any other duty that a solicitor has. However, Rule 4 states that a solicitor must also act in the best interest of a client in any matter in which they're representing the client. You must be honest and courteous in all dealings in the course of legal practice. You must deliver legal services competently, diligently, and as promptly as reasonably possible. You should avoid any compromise to your integrity and professional independence, and you have to obviously comply with the conduct rules and the law. Rule 5 states also that a solicitor must not engage in conduct in the course of legal practice or otherwise, which demonstrates that the solicitor is not a fit and proper person to practice law, or is likely to a material degree to be prejudicial to or diminish the public confidence in the administration of justice, or bring the profession into disrepute. So this reference, this rule is obviously replicated in the bar rules. There's also a few other cases about it. The case of Cummins is interesting in that Mr. Cummins was at the bar, I think, for about 40 years and managed to get away his entire career without paying a single dollar of tax. So that's, considering he was, I believe, a financial manager for several other entities, he was deriving an income and some of it, I think, was tax work. That was basically a gross abuse of his position in not fulfilling his civic duties. So that warranted a finding of permanent unfitness to practice, and he was removed from the role. Rule 19. This should be obvious, but a solicitor must not deceive or knowingly or recklessly mislead the court. You must take all necessary steps to correct any misleading statement made by you to a court as soon as possible, once you become aware that the statement was misleading. And you will not have made a misleading statement to a court simply by failing to correct an error or in a statement made to the court by the opponent or any other person. In the case of Costigan, he improperly used trust funds, failed to notify the Bar Association when he was hit with a creditor's petition, failed to provide written statements showing why he was still fit and proper to hold his practicing certificate while he was bankrupt, and failed to notify the Bar Association of other convictions. So his conduct would reasonably be regarded as disgraceful or dishonourable by his peers. He would not be regarded as a person of good fame and character for the purpose of admission, both because of the nature of his conduct in misleading the courts and engaging in legal practice and holding himself out to be a barrister when he didn't actually have a practicing certificate, and improper dealing with clients' monies advanced on account of legal costs for legal services to be provided. So as a result, he was struck off the role for professional misconduct. Ex parte applications. There may be a temptation that when you are bringing an application on an ex parte basis and you know the other side's not going to rock up, that you then think, oh, well, I can just present my version of events and no one's going to be there to contradict me. The Solicitors' conduct rules and the bar rules make it quite clear that if you're bringing an application ex parte, what you need to tell the court is actually a lot more, it's a little bit more onerous than if you did have an opponent. Rule 19.4 makes clear that a solicitor seeking any interlocutory relief in an ex parte application must disclose to the court all factual or legal matters which are within the solicitor's knowledge, are not protected by legal professional privilege, and the solicitor has reasonable grounds to believe would support an argument against granting the relief or limiting its terms adversely to the client. So basically, you have to point out, if the other side's not going to be there to present an opposing side, it actually does fall to you to say, well, here are some, these are the issues with our case, and this is what the other side would actually argue. Continues on in Rule 19.5, which states that a solicitor who has knowledge of matters which are within Rule 19.4 must seek instructions for the waiver of legal professional privilege if the matters are protected by that privilege, so as to permit the solicitor to disclose those matters. And if the client does not waive the privilege as sought, you must inform the client of the client's responsibility to authorize such disclosure and the possible consequences of not doing so. And also informing the court that the solicitor cannot assure the court that all matters which should have been disclosed have been disclosed. So you can understand a situation where you're bringing an ex parte application and your client doesn't want you to tell the court the problems with their case or the opposing arguments. You are bound by the conduct rules to do so, regardless of the fact that your client is telling you not to. In Thomas and SMP International Pty Ltd, this was an urgent ex parte freezing application brought for freezing orders, and those freezing orders were obtained improperly. There was a failure to provide full and frank disclosure. There was no undertaking sought that proceeds of the sale would not be removed from the jurisdiction, and also there was a failure to give notice of the application. In that situation, indemnity costs were ordered. This one's probably a common issue, I think, that solicitors would face, which is that Rule 25.1 of the Solicitors' Conduct Rules, which is also replicated in Bar Rule 71, states that you cannot confer with more than one lay witness at a time. So sometimes you'll have a husband and wife come in, or you'll have employees in an organisation that come in and they need to give evidence. And in those situations, you actually do need to ask people who are not the witness to leave. This goes to a point that Shana will touch on later, which is about integrity of evidence. Because obviously, they want to, and you've got to be careful, because obviously when you meet the client for the first time or in the early days, they're going to want to tell you their version of events. But the thing is that if you are preparing their written evidence, which is in the form of an affidavit, you really should not be dealing with anyone else or have anyone else in the room other than that witness until that affidavit is finalized and sworn or affirmed. Obviously, it's tainting of evidence. If you've got 3 people in a room and they're all telling you what their affidavit evidence is going to be, you get a problem in terms of everyone knows what everyone else is going to say before they've given their own evidence. This will become a big problem that will unravel very quickly before your eyes at a trial. So please don't do that. Confer with one witness at a time only. Yes. That's fine, because the support person is generally not going to be a person who's also going to be giving evidence in the matter. So but if you have a case where multiple people are going to be providing affidavits in the same matter, they really should not be near each other they shouldn't hear anyone else's evidence until they finalise their own. The only exception to this is where you're talking to your client about undertakings to a court, admissions or concessions of fact, amendments of pleadings, and compromise. So those are the ones where, you probably are going to need to get instructions from more than one person, especially if it's an institution. So those are the only acceptable exceptions. And that leads slightly to don't be a witness. Rule 27 states that in a case in which it's known or becomes apparent that a solicitor will be required to give evidence material to the determination of contested issues before the court, and the solicitor may not appear as advocate for the client in the hearing. In a case in which it is known or becomes apparent that a solicitor will be required to give evidence that's material to the determination of contested issues before the court, the solicitor, an associate of the solicitor, or a law practice of which the solicitor is a member must not continue to act for the client if doing so would prejudice the administration of justice. I think the classic fear of barristers and this witness rule is essentially a situation where you have a witness in being cross-examined, and then they suddenly say, "Oh, but my lawyer told me to put that in," or "My lawyer said to say this." You've got a problem. It's a bad look if nothing else, but it's a thing not to do. Then we come to lying clients. Sure, they don't exist, but if that happens to you, Rule 20.1 has you covered, which basically says that a solicitor who, as a result of information provided by the client or a witness called on behalf of the client, learns during a hearing or after judgment, or the decision is reserved and while it remains pending, that the client or a witness called on behalf of the client has lied in a material particular to the court, or has procured another person to lie to the court, falsified or procured another person to falsify in any way a document which has been tendered, or suppressed or procured another person to suppress material evidence upon a topic where there was a positive duty to make disclosure to the court. What do? You must refuse to take any further part in the case unless the client authorises the solicitor to inform the court of the lie, fabrication, or suppression, and must promptly inform the court of the lie, falsification, or suppression upon the client authorising you, the solicitor, to do so, but otherwise may not inform the court of the lie, falsification, or suppression. So in those cases, it would be a case of, if your client has lied, you've told them, okay, we're going to have to tell the court about this, and they are insisting that, no, you cannot do that, then all you can really do is tell the court, look, I've got an ethical issue that's arisen, and I can no longer act in this matter. That's pretty much all you've got. And now we go to pleadings and evidence, which Shana will guide you through preparing evidence that is admissible.
Thank you. All right. Thank you, Holly. I would just add on, in relation to the ex parte applications, it's handy to have in mind a line that you might use to inform the court of the things that are against you. So, for example, if my opponent were here, I anticipate that they would say against this and then tell the court what it is. I do quite a bit of work that involves ex parte applications, and it's a very serious duty. You must always be mindful of it. All right, pleadings and evidence. It's a symbiotic relationship. I'm going to talk a bit about pleadings because it is relevant to evidence. Those three things that are up on the slides there, marshal the documents, prepare a chronology based on the documents, and set out the objectively provable facts. Those are the things that need to be done before pleadings or evidence are done. The marshalling of documents is very important. You need to know what's objectively provable and have it in a chronology so you can see the sequence of events and what could or could not fit where once the client starts telling you their story. Once you've got that detailed and accurate chronology that says what did and didn't happen, prepare a detailed proof of evidence before you plead the case. Proof before pleadings is a fundamentally important rule. You need to know before you have your client swear or affirm an affidavit as to the truth of the pleadings that they're right. So get them to sign off on the even if it's just a proof of evidence that they've signed, so you know what they say and what they will say when they come to swearing or affirming an affidavit. Then at least if things go pear-shaped, and it does happen, if things go pear-shaped and the pleadings don't match the evidence ultimately, you can say, well, this is what you told me and this is what you signed up to before we finalise these pleadings. Now we need to amend, if that's your solution. But it's a very useful thing to have something concrete in writing. One of the reasons documents are so important, of course, is that documents tell the truth when witnesses might not. And you'll all be familiar with the excellent judgment of Chief Judge in Equity McClellan's in Watson and Foxman, 1995 decision. It's cited all the time in all sorts of cases, but there his honour emphasised the fallibility of the way humans remember things and the way they overlay their memories with their own self-interest. And his honour says that it is often subconsciously, it's subconsciously constructed where they add in plausible details. And Justice Jackman has characterised that as being perhaps an overly charitable view of the way we humans overlay our memories with our own self-interest. But in that judgment, what was emphasised is that you can have real difficulties with proving things based on what people say unless you have some reliable contemporaneous record or other satisfactory corroboration. So the documents are important, and starting with the documents is important. Now, you need to test what you're told, of course, and we've all been in a situation where you have a client saying, but you're meant to be on my side, when you're trying to test what it is they're saying to you. Sometimes you'll be faced with outlandish allegations where it's apparent they're outlandish because they don't match the documents, and you need to be able to have the facts to test those things with your client, and it's better that you test it in conference before they've sworn an affidavit saying this is true than that it is tested by the other side in cross-examination in court for the first time. This is just a handy little diagram of circles of relevance of evidence. Of course, the test for relevance is set out in section 55 of the Evidence Act. We're all familiar with it and how broad it is. Evidence is relevant in a proceeding as evidence that, if it were accepted, could rationally affect, directly or indirectly, the assessment of the probability of the existence of a fact in issue in the proceeding. So it's pretty broad, and there we have a little diagram. You've got, in the middle, you've got the evidence that directly proves your case. Then you've got the evidence that directly disproves the other side's case. And then, of course, there are the things on the outside that affect the probabilities of what occurred. It might not be directly relevant, but it is indirectly relevant and supports a probability. And that can be a probability as to what happened or credit. And of course, Section 55 provides that evidence is not taken to be irrelevant only because it relates only to credibility of a witness, the admissibility of other evidence, or a failure to adduce evidence. Now, the provenance of documents, it can be very important. Sometimes you will need an affidavit that sets out how a document came into existence or where it came from. There are obviously some things that are just accepted to be what they look like they are, unless it's disproven, things like bank statements, title searches. It can be very important to the case to prove where a document came from. I've got a couple of examples there. In one of those, there were 2 deeds that were relied upon by a plaintiff, by a defendant. I can't remember which party it was, but they held up these deeds and said, my mum held these shares for me on trust, and here are the trust deeds that she signed, and they were witnessed. And so there was a fight about whether these trust deeds were actually legitimately executed by the mother of the party. There were competing stories about what happened. There were witnesses who said, there was one of the witnesses to the document said, well, I'm pretty sure I was there, I was at this place, I signed it as a witness. Don't specifically remember the document, but I was there at about that time. And someone else said, well, I worked in the office and I often signed things as a witness where I hadn't seen that person actually sign them, and I saw this guy also sign things where the person who's said to have signed the deed hadn't signed it in his presence. But the nail in the coffin was really the evidence of the diary that was kept by the person said to have signed the deed when she had been travelling around the Northern Territory. And I think on that date, she referred to the cost of the caravan park and the pie shop they'd stopped at, and the evidence of where she actually was went in. And the judge, there was absolutely no way the judge could find that the deed was authentic. Another example of where documents came from being important is the next case in the same series, Arrogen and O'Mealy, where there were some privileged draft statements that one party tried to get into evidence, and what was put against them was, this has been illegally obtained and you can't use it. So the 2 stories were entertaining. One version was, I was driving down the street and I saw this guy and he gave me a call on my mobile and told me to come back and meet me in the park. I went back and met him in the park a few minutes later and he gave me an envelope with some documents and he said, here, can you give these to your brother? And the story of that witness changed over time, and it didn't stand up particularly well under cross-examination. In fact, I think Justice Young, acting Justice Young as His Honour then was, said that these were some of the worst witnesses he had seen in 28 years on the Supreme Court bench. The competing story was that someone had hacked into someone's Hotmail and stolen the emails that had been sent between the person and their lawyer. So the documents were privileged and they'd been stolen, and the judge ultimately found that that was what had happened. But sometimes you really need to test where the documents have come from and how they came to be, and sometimes a little bit of digging is warranted. Of course, some documents can self-authenticate. We know that there are some documents that are accepted. Inferences can be drawn from the face of the document that it is what it is. There is Section 58 of the Evidence Act, from which inferences can be drawn as to the relevance of a document, and Section 183 of the Evidence Act also provides for inferences to be drawn from documents. The case of Capital Securities XV Proprietary Limited, 2018 NSW, the Court of Appeal, was a case in which there was consideration of whether or not the old decision of National Australia Bank and Rusu was still good law. That was a judgment in which Justice Bryson had rejected bank statements which were sought to be tendered on the basis that there was no proof of them actually being the bank statements that they were said to be. The case has been the subject of a lot of criticism, although one of the things that His Honour referred to was the fact that that the bank statements themselves didn't name the person who was said to be involved in the relevant conduct. So there was a factual basis for it to be rejected, but nobody had taken His Honour to Section 183 of the Evidence Act, which is an important section. All right. Now, that duty to curtail evidence. That's one that Holly mentioned in relation to the Barristers rules 43 and 58, and the duty to limit evidence to what is reasonably necessary to advance and protect the client's interest. So we have a duty to curtail the evidence. You need to identify the real issues in dispute. Of course, it's got to be relevant. There is another case in the Thomas and SMP line of judgments, which was Justice Pembroke. And if you read the judgment, you can almost hear His Honour sobbing in chambers in the night as he's trying to read this evidence. And he says that prior to the commencement of the hearing, I embarked on a close examination of Mr Sullivan's affidavit, comparing it line by line with the objections that have been made to it. It's been a time-consuming, painstaking, but ultimately unrewarding task. After 3,000 paragraphs, I ceased. I could go no longer. Could go no further. And the evidence was just vast. And His Honour emphasised there the legal practitioner's duty to filter the outpourings of our clients. We've all been in a position where you have a client who just wants to get the story off their chest and to unburden themselves of their memories. But we owe a duty to the court. It's not merely a rule of practice or etiquette. We have a substantive duty to control what our clients put into their affidavits. And it's very useful to have an authority like this when your client is saying, but I need to say this. You can say, well, I'm really sorry, but I have a duty to uphold. I have a duty to the court, and I simply can't put this in. And it's been said also by the Court of Appeal in 2019 in Olsen and Olsen, no matter how determined a plaintiff may be to unburden himself of memories, real or imagined, distant family events, his solicitor and counsel are duty-bound to restrain his enthusiasms. So it's a duty owed by solicitors and by barristers. All right. Now, integrity of evidence. This is important. It's all important, of course, but integrity of evidence. We must not advise or suggest to a witness that false or misleading evidence should be given or condone another person doing it. I think we all know that. Rule 24.1.1. Must not coach a witness by advising what answers the witness should give to questions when asked. So the integrity of evidence, of course, has been the subject of some fairly recent case law, certainly in respect of conversations. I'll come to that in a moment. Things that will not breach Rule 24.1, expressing a general admonition to tell the truth, questioning and testing in conference the version of events to be given by the witness, and there we come back to that, having the documents and testing whether what they're saying stacks up with what the other evidence is, drawing the witness's attention to inconsistencies or other difficulties with the evidence. But when you're doing that, you can't encourage them to give evidence that's different from the evidence they believe to be true. That can be really difficult when you get a client who says, but no, this is what happened, and the documents say something that is entirely different. And there's no clear, easy answer to that. Sometimes it's a matter of calling on someone more senior, and it can be quite difficult to manage. Now, integrity of evidence and conversations. Most of us will be aware of the recent line of cases on this issue leading up to Wild and Majuri, which is a Court of Appeal judgment from last year. I think it's fair to say that the first case that really kicked this off is Keynes Hire, Pty Limited and Anderson Aviation Australia, where Justice Jackman considered the question of evidence that is of a conversation with words to the effect and using quotation marks. And His Honour talked about how the primary duty of a witness is one of honesty, and that witnesses shouldn't be compelled or encouraged into uttering untruths on oath by giving a form of words in direct speech which they're not happy with and which they can't actually recollect in preference to their own words in indirect speech. And there are, I'm sure we've all been in those conferences where the witness will remember the gist of what was said in pretty broad terms, and they just don't remember the detail. And the practice has been to try to reconstruct with them what would have been said. Well, Justice Jackman has said in this case that is it's logically, ethically and grammatically wrong. And you can see why that is, frankly. So His Honour said it's ethically wrong because the evidence given as a result of that process conceals the true nature and quality of the witness's memory and conveys a false impression of that memory. Now, after that, we had the New South Wales Court of Appeal in Gan and G 2023, so July of 2023, say we agree with what Justice Jackman said in that case. That was Justice White with Justices Simpson and Baston agreeing. It was obiter, but it was considered obiter, and it was by all three of the judges who decided that case. So Court of Appeal agrees. Then we have Justice Jackman, about a year after the first decision in Goldstone Capital, where His Honour found that the evidence that was in words to the effect form was didn't do the witness any favours as to credibility, because he said, this judgment was handed down a year ago. You should all know by now that you shouldn't be doing words to the effect in your evidence, and so I'm going to find that this witness is not a credible witness based on the way this evidence has been done. Then we get to Wilder Majuri in the Court of Appeal. So that was handed down in September of last year, the 26th of September. Chief Justice Bell was critical of Justice Jackman's observations in Keynes Hire, and it's worth reading the judgments. They disagree with one another in some respects, but fundamentally I think they agree in some important ways. Justice White did not agree with Chief Justice Bell's criticisms of Justice Jackman's judgment, and neither Chief Justice Bell nor Justice Kirk thought it was unethical to set out the evidence as words to the effect, if that's what it's stated as being. But I think really the take-home point is that what we should be doing is writing what the witness remembers. Don't try to make up a conversation that they don't remember. If what they remember is the gist of what was said, or it's in conclusion form, that's what they remember, put it down. I think from these cases what is clear is that evidence that's in that form that once would have been objected to as being inadmissible as to form or conclusion is no longer going to be found to be inadmissible. It may have less weight because it's not precise, but if the evidence is too precise, it may have very little weight because it's obviously not what they actually remember in some instances. And it may be that the witness remembers a series of words. If they remember a series of words, put those in, but then otherwise say, but I don't recall the precise words said for the rest of the conversation. The gist of it was, and then whatever they do remember. So I think what we all need to be very careful with is just writing what the witness remembers in the form they remember it, and saying what is the form. You know, if they actually remember the words, say I remember these words. If all they remember is the gist, then that's what should be said. There's a really good paper that was published in Bar News, I've put the citation there, about the direct speech debate. It's well worth a read, and Justice White refers to that paper in his judgment in Wilder Majuri. I do encourage you to read the judgment. It's very useful. To the extent that it's obiter, and it does have judges disagreeing with one another, of course. But I think the take-home point is write what the witness remembers. All right, now moving on to pleading and proving fraud. I'll go through some rules that are relevant to pleading and proving fraud. What is fraud? It has to be clearly pleaded and properly particularised with a proper basis. All right, so Solicitors Rules 21.1. You need to take care to ensure that your advice to invoke the coercive powers of the court is reasonably justified by the material then available to the solicitor, appropriate for the robust advancement of the case, not given principally in order to harass or embarrass a person, and not given principally in order to gain some collateral advantage for the client or the solicitor or a third party. Now, did that change? No, 21.2. You have to take care to ensure that decisions to make allegations or suggestions under privilege against any person are reasonably justified by the material then available to you, appropriate for the robust advancement of the case, and not made principally in order to harass or embarrass a person. And you must not allege any matter of fact in any court document you've settled, submission in a hearing, an opening address, or the course of a closing address or submission, unless you believe on reasonable grounds that the factual material already available provides a proper basis to do so. Oops. There we go. And then, specific to fraud, Rule 21.4, you must not allege any matter of fact amounting to criminality, fraud, or other serious misconduct against any person unless you believe on reasonable grounds that available material by which the allegation could be supported provides a proper basis for it. And you need to advise the client of the seriousness of the allegation and the possible consequences for them if the case is not made out. So you need to test, in particular, you need to test that kind of evidence. If there is a serious allegation being made, if there is fraud alleged, you really need to take some extra steps to make sure that it's properly based. Rule 21.6, you can regard the opinion of an instructing solicitor that material is credible and can support an allegation. Now, fraud, what is fraud? Fraud is dishonesty, really, at its heart. Fraud it can be unconscionable conduct. Fraud is conduct of a kind that is, not honest. Allegations of fraud have to be clearly pleaded and properly particularised. You should not make allegations of fraud unless you're satisfied it's in proper form and it has a proper basis. So it is an area where you need to be very careful. As I've said out there, the court will not give relief on an issue involving fraud unless the allegation has been clearly raised in the pleadings. And the court rules so the Uniform Civil Procedure rules tell us that we need to properly plead fraud. Sub-rule 3. And allegations of behaviour in the nature of fraud have to be properly particularised. So it's not just in the Solicitors' Conduct Rules, it's also in the court rules. I thought there was one more slide after that, but there's not. But that's actually very good timing because we have 5 minutes to go. So are there any questions? I say to an audience of only 2 people here in person, but I think we have people online. So we just need to refresh. I don't think we do have any questions online.
Well, one thing that comes to mind is the preparation of evidence and dealing with one witness at a time. Very commonly, I have found, when you're preparing 2 affidavits and they take more than a day to prepare and email versions being sent, you find that the 2 witnesses between themselves are comparing notes. I'm not sure how you can ever control that.
Yes. So the question is about where you have witnesses who are both giving evidence, it takes more than one day to prepare the evidence, and there are emails going back and forth with drafts, and the question of witnesses talking to each other about their affidavits when they're not there in your office. You need to give them some really stern warnings about that, and maybe share a horror story or two about people being cross-examined on whether or not they've discussed their evidence with anyone else. I mean, you can only tell people that they must not do it, and that it's very important that they don't discuss their evidence with one another. It is fundamentally important, and I've certainly... I was in a case a few years ago where there were two almost identical conversations in affidavits that were sworn by two of the witnesses on the other side, but the conversations were said to have been in another language, so they were in Sicilian dialect 15 years earlier, and yet they appeared in identical terms in both of the affidavits. And what Justice Emmett did in that case was say, well, this is no use to me. I just need to get oral evidence from these witnesses. And then they gave the evidence orally. He ruled that the evidence was inadmissible, ultimately, in the affidavits. He got them to give oral evidence, and it didn't stack up anywhere near what was in the affidavits. But there were adverse credit findings because they had these identical passages from conversations that were said to have occurred 15 years ago. So their whole case just crumbled because of that. It was the important plank in their case, was the representations that were said to be made. I mean, I've given warnings about that just using horror stories, but whether or not witnesses and clients are going to take that on board and actually honour what they've said they're going to is unfortunately outside your control. And they will ultimately wear it in the witness box if it goes on to hearing and they've done that and they're asked the question about whether they've discussed their evidence with another witness. But on the question of support people as well, I have certainly had clients and witnesses say, I need this person to be with me while I'm preparing the evidence. I can't do it without them. And you just have to say, I'm really sorry, but they are also a witness in the case, and we cannot allow that. The solicitor's rules tell me I can't. I just can't. and again, it's nice to have the solicitor's rule to say, here it is, you can see what it says. I can't do this for you. It's not just you being difficult. So Court of Appeal judgments and solicitors' conduct rules, very handy for some things.
And I suppose it's knowing who is likely to become a witness as well. So what if you have someone that is a support person and then you might get some evidence from them later on?
Yes. So the question, just so that others at home can hear what the question was, is, or more of a comment that sometimes you might not know who is going to be a witness. As soon as you identify that there is a prospect that they will be a witness, you need to pull up and separate them. And a few probing questions from the outset can be a good way to go. Were you there for any of these events type questions, just to get a feel for whether they are someone who might have something to say about the relevant events. Are there any questions online? No? All right. Well, that's us.